churning, my lord, as I see it emerging, which will call for a lordship's pronouncement. A step more than the right to marry is there a corresponding obligation, a correlative duty in the union to recognize, my lord, the association of non-heterosexual couples as married couple in a non-discriminatory manner? That is, my lord, one is I will establish prima facie that I have a fundamental right to marry. I don't want to confine myself to the statutes, my lord. And I will tell you, lordships, why very briefly. Having demonstrated that, it has come in discussion, it has been argued that who stops you? By all means, have a celebration, have a marriage. But if you seek affiliation or recognition, can you vest in the respondent an obligation, just as they have, my lord, granted it for non-heterosexual couples? That will be the primary question, my lord, because it was argued throughout that nobody stops them from calling their association a marriage, but don't expect recognition or affiliation. I'm using the word affiliation, my lord, in a broader sense.
You are trying to locate a duty.
Duty, my lord, duty.
Your
Now, my lord,
question is locating a duty should stand on a different footing from that of discrimination.
locating the duty will discrimination, and for that, my lord, we will have to go back a bit. As my lord, the Honorable Justice Butt rightly said, put yourself in the armchair as if you are in 1954. No, my lord, put yourself in the armchair as if you are in 1954.
No?
Sir, I'll address, my lord, the Honorable Justice Narasimha's question. My lord, I'm going to establish a right, and then, my lord, put the duty independent of that. In 1954, no doubt there was a statute of 1870. Sorry, my lords are in conference. An 1872 statute, my lord, which had an onerous condition that you must give up your religion. The 1872 Special Marriage Act, which was repealed by the 1954 Special Marriage Act, said for those who do not profess Hindu, Buddhist, Christian, Sikh religion, because you have to give up the religion, my lord. Now, in 1950, when the Constitution came into force, marriages were by personal laws. Entry 5 in list, my lord, 3, the field of legislation was demarcated. If, my lord, an interfaith couple had come to your lordships and said, I don't want to give up my religion, I want the same status that people who have gone the religious route and have come in an association of marriage are being given by the state in all their activities, my lord, in terms of pension, insurance, and all those things. In my respectful submission, your lordships would have found that right and found a positive obligation. Found a positive obligation in commanding the state. Your lordship would not have turned the interreligious couple at the door and said, there is no legislation today. The legislation says you have to give up your religion, the 1872 Act. Your lordship would have found that to be unconstitutional, number one. And your lordships would have recognized their right to marry without giving up their religion, my lord, in an interreligious marriage. Today, my lord, after Navtej, in 50 also, my lord, this 377 had considered this association as unnatural. The natural association was of a man and a woman cohabiting without force. But this was unnatural. Consensual cohabitation was unnatural. So it could not have recognized. They would have had a valid defense in saying it's an offense. It became natural, purely natural. With Navtej having, my lord, exorcised from 377 the penal part of the provision. Now, my lord, in this scenario, if, my lord, marriage is the ultimate union as has been developed, my lord, in the jurisprudence that we have placed.
Nathan,
Yes.
now, no doubt this is a very this hypothesis is very attractive to dwell upon in a 2023 court. But the fact remains that in the 1950 court, viewed fundamental rights essentially very differently. With A.K. Gopalan, etc.
Milord, we
So
will
if we
have
have to transpose ourselves back then,
No, Milord.
we had a far segregated or fragmented view of fundamental right. What you are doing essentially is placing that situation and transposing it to the present
Milord,
context.
My lord raised that argument of what would have been the situation between 50 and 54. It's a very important, my lord,
See,
question.
that, you see, it's not just interfaith. Till 1946, even inter-caste marriages were
Caste marriages.
prohibited.
So, my lord,
So the 54 Act went beyond religion. It actually demolished all those other barriers. So in that sense, that statutory intervention brought that about. So
now,
both parts, see, you may be right. Now the question is to take forward that hypothesis. How do you bolster it?
yes.
With which kind of precedent do you bolster?
Yes, my lord. Kindly have a look at my note.
You are relying on that Narula. You're relying on Salmon.
I am relying
You're
on
relying on Cooley.
Salmon for, my lord, right and correlative duty.
Yes.
I am relying on, my lord, the positive obligation judgments,
And you're relying on Cooley's.
Cooley's
declaration.
constitutional limitations. I am relying on, my lord, what will of the people is. It is argued that will of the people in the context of a referendum. Will of the people, your lordships have said, is the constitution. Your lordships in constitution benches have said will of the people is already reflected in the constitution.
I'm going to rely on those passages in B.R. Kapoor also.
We are Kapoor also, my lord. Will of the people. My lord. The correlative duty. I have even gone a step further and argued in the alternate. Assume it is a privilege they are extending. Even in a privilege, your lordships have said you can't discriminate. In the most, my lord, noxious of trades,
Yes, you are right.
if you now what is this, my lord? Is it a right they confer by exercising their duty?
Nandraj Jaiswal.
Nandlal Jaiswal. I quoted Nandlal Jaiswal in the note.
You did.
Now, my lord, let me assume by forming statutes, by regulating it, they are giving some rights, my lord, or deem it as a privilege. In both, argue on both prongs, my lord. Can you now discriminate? Can you now discriminate, my lord, is the question. So the real question before your lordship is, subject to correction, my lord, the right to marry, yes. Is there a duty in them to recognize this association as a marriage and extend the privileges which heterosexual couples have, my lord, come to enjoy? And if your lordship asks that question, my lord, some water.
Not to sound a spoiler, just one question. Then in that case.
No, my lord, it's
the
only your
next-
lordship's, my
Next
lord.
case would, the
My lord,
next
queries which bring out.
question would be,
Yes,
what all relationships would you locate the duty?
yes.
In the case of a live-in also, then you will say that the law should cater to every kind of relationship.
No, my lord. My lord, that is an argument addressed. Incestuous relationship was argued. I'm just
Will
giving an
not take it
illustration.
to that extreme.
Three people coming together was argued. My lord, 1 minute, I can't. Whatever you are giving the heterosexual couple, there I am putting it on discrimination. Today, incestuous relationship is barred in heterosexuals. Prohibited degree is barred in heterosexuals. My lord, any other, my lord, three people coming together, the argument Mr. Sibal gave is barred in heterosexuals. My discrimination argument will fall flat. But if you are extending, my lord, a certain right, call it right, call it privilege, can you then, my lord, post Navtej when you have called this relationship natural, when it is no longer unnatural, and when your lordship say we have to be put on even platform, don't they have, my lord, as Salmon says, If you have this much, they have, my lord, a duty which they have extended to, my lord, a set of heterosexual couple.
Mr. Vishwanathan,
Yes.
I mean, just as a matter of jurisprudential curiosity, I dealt with this argument in my
Dissent.
in
Aadhaar.
Aadhaar. The only problem it's a dissent.
So,
And if you see my Aadhaar judgment, which is 2019 1 SEC, it is at 664.
we are given it here.
There's a segment called Development as Freedom,
Yes, my lord.
and where after citing Amartya Sen and Martha Nussbaum and adverting to the capability theory, I referred to Henry Shue. And I say Henry Shue suggests that rights give rise to corresponding duties.
Yes, my lord.
These duties include 1, a duty to respect, 2, a duty to protect, and 3, a duty to fulfill. Just see this? I mean, just
My lord, no, my lord, that is exactly, my lord, we should have
just
placed
see,
that.
you have that?
We
By the way,
read it in
or
the
we can-
context.
I can share it with you if you
My
want.
lord,
The judgment is at, just see, at page 790. 790.
my lord, we are getting the book, my lord. My lord, in fact, what your lordship now read out echoes
Page
What?
790.
Saman.
And at page para 1222.
Yes.
Actually, see para 1220. The notion that liberty only consists of freedom from restraint does not complete the universe of its discourse.
Yes.
Broader notions of liberty are cognizant of the fact that individuals must be enabled to pursue their capacities to the fullest degree. Social and economic discrimination poses real barriers to access education, resources, and the means to a dignified life. This approach to understanding the content of freedom construes the ability to lead a dignified existence as essential to the conception of liberty and freedom. Then I cite development as freedom, which is Amartya Sen. Then para 1222.
Yes, my lord.
The notion of freedom as an agency has been developed by Sen as part of the capability theory. Then
Necessary consequence of focusing upon major sources of unfreedom in a social and economic perspective is that the removal of these restraints is essential to the realization of freedom.
then
If true freedom is to be achieved through the removal of conditions which cause social and economic deprivation, the role of the state is not confined to an absence of restraint. On the contrary, the state has a positive obligation to enhance individual capabilities. Martha Nussbaum argues that realizing freedom requires the state to discharge positive duties. Nussbaum expresses a threshold level of
now
capability
just
below
see
which.
para 1224. In
Yes,
fact,
my lord.
solicitor will remember Zoeb Hussain had made this argument
Yes, my
actually.
Henry Shue suggests that rights give rise to corresponding duties. These duties include duty to respect, duty to protect, and duty to fulfill. Duties of respect embody a restraint on affecting the rights of others. Duties to protect mandate that the state must restrain others in the same manner as it restrains itself. The state's duty of non-interference extends to private individuals. The duty to fulfill connotes aiding the deprived in the realization of rights. This imposes a corresponding duty to create the conditions which will facilitate the realization of the right. The right which is protected for the individual will also signify an expectation that the state must create institutions enabling the exercise of facilitative measures or programs of action of an affirmative nature.
And the postulate is that these duties, affirmative duties of the state, extend in the welfare area. But I said that this is not just confined to the welfare area, but it can include the more political or the more social.
Social, my lord.